Okay, so let's call this meeting to order. Here we are, so let's go around the room. And we always make Miss Hannah start. Do you like that? Good, good. Jessica Giles.
Victoria Romanoff.
John Albert.
With us is Village Attorney Guy Crow, also Deputy Clerk Morgan Wright. Okay, so this is a working session. The agenda is posted, and we'll do that. So this is an opportunity where once upon a time, and I wasn't part of the board then, John, but I heard tell the board used to only meet when there was an application or something to review, which didn't necessarily mean every month.
That was during my time.
Okay.
We met once over a mailbox. Would it be 4 inches here or 4 inches there? And we were in a tie.
Yeah.
2.5 inches to the left.
So we do not have any application materials new before us to discuss today, nor is the applicant present, nor is MRB present. So some of the business that we have been doing, we aren't doing, which is also why there is not this evening a period of public comment, because this is a working session as posted by the agenda for us to go over this general theory of how one reviews an application, right? And a determination for approval or disapproval, so how you do that. And we've talked about it, but I finally was able to put together a little bit more of a concise document, though it's not very attractively formatted. Guy has some more properly formatted documents that he will go over, talking about, again, in general, none of this is specific to any application in front of this board, about when you do it as a part of the determination process, at what stage could a board put on conditions and what sorts of conditions are appropriate to put on. Some of you have been part of processes where that happened. I don't believe Hannah and I have been on the board when we did that, so I thought it was a good opportunity for review. And the first agenda item is to approve the minutes. So we are starting with February 28th. Does everybody have that in front of them? Okay. Let's see, has anyone had a chance to review these at home and found any issues with these minutes? Okay. Oh, cool. Nice. Okay. Is there a motion to approve the minutes as in front of us from February 28th, 2019?
So moved. Second.
Excellent. All in favor? Opposed? Excellent. Approved. Next minutes are March 28th. And okay. Great. So for folks in the audience, if you want to know, and these are all public record, of course. So the meeting on March 28th, it does note that that's when we talk specifically more about streetscape and plantings and building materials with the 46 South Street applicant, ever-present water mitigation discussion in the nursery school, and notes some public comment. But we didn't take any actions that meeting. Anyone have any adjustments to March 28th, or is there a motion to?
Was it MRB at that meeting? Do we?
Thank you.
That would be a village.
No, they don't. Thank you. Yes, Colin from MRB was there. Can you make that adjustment? Thank you, John. Likewise, that's true. They were not there. Okay. Great. So we'll make that adjustment. You can resubmit them, and then we can approve those. Okay. Great. So let's go to the document that I generated. Let's just work through it, I think.
Which one is that?
And that's the one that says, here's my stab at creating an outline for application review. And so what I did is what many of you may have done at home already is, so we have site plan review as defined in the code, and then we have once a determination that it's a subdivision, then there's a set of regulations. And sometimes those align very easily and there's nothing left out. Sometimes one was meshing together to make sure all of the crucial steps were identified. I did have Guy give a cursory look at it, and again, it's a pretty rudimentary outline, but to me, it makes sense, right? So nothing got missed. In case anyone was feeling like we didn't do things, or I think largely for me, part of my investigation in it was to say, what are the timelines? And there was that notion, right, that New York State says 62 days after approval of preliminary plat, but ours are all 45 days, but yet they can be extended. And so to make that not feel nebulous, we started in on that. So let's just, I think, walk through it, and then if someone has a question, interrupt me, or an observation that I left off. Anybody, feel free to chime in if you think that I'm misspeaking. So we're looking at, and I have the wrong dot there, it's 8.12 is the part of the site plan review, where it notes that initially, so there's an application for building, for a project, and it comes to the village office. At that point, the zoning officer determines if site plan review is necessary for the planning board, right? And then I cite the code for a reference of where that's stated. So the comments that you're seeing underneath here, I'm not going to address today because they were for our use to see how we were going in the progress of 46 South Street. So once that happens, then if it goes between in front of the planning board, then before you can give site plan review approval, you have to do a SEQRA. Within then step 4, the public posting of the review process is a minimum of 7 days until you can make, this is all under site plan review, a determination. And then we look, so I feel like there's a step missing now that I'm thinking about this in general. What am I missing there? No, it's all site plan review. No, that's it. Okay, so you did the SEQRA and you fulfilled the requirements of looking at the documents under the site plan review process. You can choose to include all of that long list of documents or not. We addressed that when we were looking at another applicant on Lake Street. You can say we need all these things. You can say we don't. We feel sufficient to review this, but you must complete a SEQRA. I think that was the most important part that I was pointing out there. Okay, and then, so these are all the numbers underneath 8.12. The planning board schedules consideration of the application at the earliest possible meeting. The board may establish its procedures and requirements within the framework provided by this chapter for conducting site plan review. So what was key to me here, it says may. So here we have, right, again, looking at subdivision, how does it relate to site plan review? Site plan review lays out the determination process that the board may use, which gives us room to pick and choose. Now, again, within that after, you have to have a public hearing prior to a final decision, and then there's another timeline within 30 days of a public hearing, and on an application, the board will render one of the following decisions, which I didn't include, but it's that's when there's a final application, or an application. And this is where some of the language got a little squirrely in terms of preliminary, final application. And that's why I think we have largely been relying on the subdivision regulations, because we should, because it is a subdivision, we made that determination. And the outline is a little bit more clear and more concise.
A question. Since we now are yet looking with additional things like a schoolhouse and additional parking and more assets.
So now you're talking not in general, but you want to discuss the specific application in front of the board.
I feel enough changes have occurred in recent history with this project where a public hearing and public input with all the final presentations, I think would be appropriate.
So before we discuss, as I said at the beginning, and the intention of this meeting was to be clear on the process in general, is there another application? No, there was going to maybe be another application in front of the board, but there isn't at this time. So let's not discuss
But
right
when
now.
that one occurs, possibly
Let's wait until we're ready to talk about
public
that,
input on that.
because it will actually address that notion of the hearing in the subdivision regulations, because we did have a public hearing.
Yeah,
We
but
did have
I
a
think there are
public
enough
hearing.
major changes where the plan is such today that we actually might want the public really to
You
participate.
could and you could not, let's address that, that comes up later in this analysis.
Okay, later time.
So here's another key point, right? 812.7, extension of deadlines. This is still under site plan review. All deadlines for decisions on a site plan review application may be extended upon mutual agreement by the planning board and the applicant. So that's why right now we are still in a discussion. There has not, unless there was a document on a recent submission, which I didn't look at thoroughly, that says this is the final preliminary plat. That hasn't been submitted. And that's okay, we're in mutual consent with the applicant. Now, why that's also significant is because if you don't have mutual consent, right, Guy, then the applicant can say, no, you had 5 days to make this, you have 7, whatever the term, they can say, this is in your code, and then we have to step 2 and make decisions.
With site planning, they would not necessarily have that authority, depending upon how you can have a just reason for not meeting the deadline. With subdivision, that's not necessarily the case.
Okay.
So, that's why rather than gamble that there could be an argument that there's a default approval, we sought the consent and cooperation to extend until there was a final application to simultaneously review site plan and subdivision together, so you weren't segmenting one from the other and not looking at the overall impacts together.
Okay. So now moving into subdivision regulations, I just made some highlights on this. I guess it's kind of silly. Obviously part of what's driving this is that we do have a major application in front of us. I just want to be careful not to address a lot of specifics about that particular application. But once you do decide that it is a major subdivision, I focused on the major subdivision regulations. Obviously there are minor subdivision regulations. They are not highlighted here because they are less complex. Section 435 of that A says 45 days after submission of a preliminary plat, there is a public hearing. And then 45 days after the date of the conclusion of the public hearing, the planning board shall approve or disapprove the preliminary plat. Now, again, we do not have an official preliminary plat, correct?
I believe you did.
We did, and then it got revamped. So
So
we're now waiting for a
you haven't yet approved a preliminary plat because there's not a final preliminary plat in front of you, and that's part of the problem with the vernacular subdivision is you have a preliminary plat, a final preliminary plat, a preliminary final plat, and a final plat.
Okay.
And you almost want to end that with do-da.
Right, there you go, approved final subdivision plat, right. So that's significant. But again, the timeline for current application is not relevant because things have been extended. You have to do a SEQRA, so both subdivision and site plan review are clear that you do a SEQRA. We did that. So preliminary plat, final preliminary plat. So let's say that it was a preliminary plat that was submitted. It's not been a final preliminary plat because we've been in discussion. Once that is submitted, then 45 days, then you could, then you have to make some determinations. Once that's there, then the planning board has to.
I'm a little confused by the term plat. I'm assuming it's this plan.
It's the whole thing, yeah.
Right, they're combined. A plat refers to the subdivisional land. In other words, regardless of the use, how you're dividing up land into various lots and blocks. The subdivision plat is a term of art that refers to the subdivision. It has to do with where the new tax lines are going to be, where the boundaries of the roads are going to be, things like that.
So it's not about lighting or drainage or
No, and again, understanding like you're on point when you say it's hard to figure out how you do a simultaneous review and how the processes mesh, but that's part of what I've provided with you is a much shorter version of a presentation that was given to the New York Planning Federation at their summer school training in Syracuse a couple of years ago. And what it did was it attacked land use generally chronologically.
Yeah,
From
okay.
New York first implemented amended zoning in 1909, where did they find the holes were left where they weren't getting the regulation that was needed? Then came subdivision, up where there were still problems, then came site plan. And if you understand the holes that were being plugged, it starts to all make a little more sense. I'm not going to say you can make absolute sense out of all the judicial decisions, but there are threads and themes that run through it, and that's what I'm going to focus on.
Okay, which might tighten up some of these
Quick
notions.
question on that, just a quick question. Since the developers have acquired additional acreage, and the school layout and the parking lot for that was really not part of our SEQRA review, was it? In other words,
No, sorry, wait, what?
the new acquisition of land that was
It's a
purchased.
separate parcel. The
A
house
separate
they bought?
parcel that will become, well, no, for the road, it's being used for the entrance road from South Street. All I'm asking for that is that something that will go under any review process, since the site plan or the plat that we last looked at, the school wasn't strongly yet defined and the parking wasn't defined. But least of all, the new parcel that was acquired by the developers was until very recently not part of the total parcel.
So
How
again,
does that affect our decision making?
Vicki, these are really great questions. Let's get through the notion
Okay.
of how we do this
All right,
before we really
Okay.
dig into those very hot button
okay. In
topics
other words, get through this first.
that can get us in all kinds of rabbit holes and legal liability without an applicant present. And that is not the purpose of this working session.
Okay, so don't drift there today.
Don't drift there today.
Okay.
Yeah, make those good questions. Have those good notes. You also always have the village attorney to help answer those questions.
Right, not
When
today.
you need to.
Okay,
I think
that's
not
what it is.
today, because that's a whole other.
Okay, but it does, you understand, it opens certain doors.
I'm not saying don't ever ask
Yeah.
those questions,
Not-
and make sure you
not
lose
right now.
track of them.
Got it.
Okay.
Got
Because then here, there, 440, right? Within 6 months after approval of preliminary plat, the applicant must file an application for approval of final subdivision plat. So there we have this notion of preliminary versus final and all of those sorts of things. And maybe it's actually more useful for Guy to do his bit, because it's going to be more concise. I don't know that I need to continue on with like pointing out
Well, just,
all the complexities of our thing.
you know, one of the subdivision is, and site plan are very different than a lot of other things in Article 7 of the village law. In other words, when you build a subdivision law, you build a site plan law within your zoning or a standalone. If you have zoning, usually it's part of zoning. You have the authority to do supersession, to look at things that you want to do differently than the state statutes provide. There's special rules for that. There are some rules you're allowed to exceed. There are some rules that you're not allowed to exceed or supersede. And in the end, what you end up looking at is, why does it all work that way? Why can I supersede subdivision 2 of 7-712A, but I can't supersede subdivision 3? What the heck is going on? And it really comes down to some of the historical stuff, and down to whether you're looking at and considering an applicant's rights or an applicant's privileges. Okay? Very big difference. Subdivision is more of a privilege. A variance is a right. You have a constitutional right to seek a variance. That's why ZBAs have, when you do adopt a law regarding ZBAs, you have very little supersession authority, and they're supposed to act more like a judicial body than an administrative or legislative body. And that's the underpinning of this. So,
Okay.
so sort of try to put it into a bit of a nutshell, and then I'll start getting into more of the presentation side of it. I was going to focus more on the concept of conditions in subdivision and site planning, because I think you're going to have a number of them here. And that assumes you get to an approval on what is proposed. You may finally come in the door and very different than what you think it will look like. We don't know yet. But the problem of conditions is that uses standing alone can't necessarily be defined. So if you have a zoning ordinance that says home occupations are okay, and someone's operating a home occupation, whether it's a dentist working in his house or someone who is doing home canning and going to the farmer's market. Let's say if you have a concept of being a good neighbor, that you want your neighbor to be very successful. At what point does that home occupation start to cross the bridge and become a point of sale for retail goods? Or become a parking lot for a never-ending stream of customers going in for dental work? At what point does it graduate from a home occupation to sort of a commercial use hiding inside of your residential area? Where's that bridge? And that's in a way what zoning and conditions in zoning, whether they're in the zoning regulations as an affirmative thing, you can't have a sign over a certain size, is a very common condition for allowing a home occupation. To actually putting a condition in place regarding the home occupation, such as no more than a certain number of employees present at any one time, or where they park their cars. So that's really where it comes down to. When you start to look at what is the origin of zoning and all these different police powers that surround the development of conditions, it really comes down to three things. It comes down to the Constitution, principally takings, property rights, and equal protection. Those are sort of the three legs of the stool that zoning and the police powers stand on. And most of the determinations for or against a condition or an approval or denial, in some respect, legally or equitably, are going to be resting on one of those three stools.
Sorry, the constitutional property rights.
Takings, property rights, and equal protection.
Takings?
Yep.
What's that?
That's where if you impose too onerous a condition, you've done what's called an administrative taking, and you're liable to the landowner for the taking of property rights. That's the big hot button issue in the federal courts right now. That's the birthplace of Section 1983. That's the federal U.S. Supreme Court determinations of 20 and 30 years ago that are just now starting to be fully implemented in New York, and some of that's in this presentation. So I'll just start reading, and then we can stop at each section. I'm not intending to go verbatim, word for word through this presentation. Okay, that's way beyond what we would do here, or at least what I think was appropriate to do here. What I want to do is go over sort of like an overview on some of these issues, and this adds detail. This adds some chewiness to the issues. Gives you some cases, some quotes, things to look at. Generally speaking, whenever I'm directly quoted in court, you're going to see blue text as opposed to black text. And there are cases that sometimes it's better to just quote exactly what the United States Supreme Court has said, because then you avoid people saying you're cherry picking the language and interpreting it. So I just give it to you straight. Here's what the court said. They're not pulling punches on this stuff.
May I ask a very quick question? This, you call this, what we just got this handout from you. Thank you for the large text. It says zoning. Is this based on our current zoning local here?
No,
Or is
this
this
is
based on
general.
New York State zoning? Or what is
General,
this based on?
this is based on New York State. It's general.
This is New York
And
State.
the reason I start with zoning is
Not
because...
specifically here.
Correct.
Okay.
The reason I start with zoning is because that's where your police powers are born. Site plan review is part of zoning, and it relies on the backbone of zoning in order to have authority, force, and effect. Subdivision can stand alone, site plan can stand alone, but it's all interrelated. And zoning is really, conditions really have their origin in the police power in the concept of zoning. In New York State, zoning was officially sanctioned in 1909. Okay, that was the first time the state of New York said, hey, villages, towns, you can do zoning. It's not an inherent power of local government. New York State has the power exclusively, and it has chosen to delegate that authority to the village. And the Village Board of Trustees has adopted a zoning law, made certain legislative determinations, and then delegated the authority to the planning board, which is consistent with the statutory scheme. And I cite the lead case that really explains how this all works. But the authority that's delegated under zoning is limited to the promotion of public health, safety, morals, and the general welfare. And sometimes you'll see the word wheel if you go into old enough case law, a general wheel. People have trouble with that term, but it's a very concise meaning in its historical context. Today we see general welfare. So general welfare is very broad, but it's not unlimited. General welfare includes The regulation must be within the recognized scope of police powers of the municipality. In other words, it must further a legitimate object of government. Secondly, it must be achieved in a manner authorized by New York State. And third, it must be related to the use of the land and not, for example, the operation of the business itself. So if you condition something that you're approving on only while that person owns and operates that business on the land, that's tied to the person, not the land. That's not permissible.
Okay.
And you'll see some surprising examples of that in the case law. So I do give an example of a grocery store or convenience store is a permitted use in a business district, but a buffering rule says that no business could operate within a certain distance of a neighborhood residential district between 11 p.m. and 6 a.m. Such a rule will usually fail in the face of an application from a 24-hour 7-Eleven store being sited in the business district. Why? That would surprise most people. Buffering residential zone seems pretty prototypically something you can do. And in the outline I gave you, I cite the cases that say this. One, it's an unconstitutional exercise of the police power as it deprives 7-Eleven of its right to use its property without due process. Two, such a rule violates the uniformity as a store located a mere 50 feet further away could be open 24/7 within the same zone. Why do you treat those two businesses with identical impacts differently? And then third, such a rule actually regulates the business itself, its hours of operation, and not the underlying use of the land. And there are some exceptions. You can sort of get close to that edge. There are some exceptions, and there are certain types of newer zoning schemes that can help regulate some of this. But it tells you that the lines aren't always as obvious as you might think. So these training materials, which are sort of a work in progress, provide cases that illustrate these points in most of the other standards in here. But making sense out of some of this requires some understanding of the constitutional principles, as when you're undertaking your review, you're reviewing the protected property rights of the applicant. They have rights in that property, so whether you're dealing with an allowed use or a not allowed use makes a huge difference in terms of the scope of the conditions you can impose. And as I said earlier, knowing the historical evolution of land controls and what gaps subdivision was trying to fill in the zoning scheme, and what gaps site plan and special use permitting, which frankly special use permitting is on the way out. If you can find a modern planner that thinks it's a good tool, let me know. I'd like to talk to them. But special site plan review filled some gaps that subdivision didn't. So as the village subdivisions rule, village law permits, and I quote, conditional approval of a final plat. The condition can be stated on the plat, or it can require fulfillment before sealing and endorsing the plat. However, absent fraud or substantial cause, a planning board has no authority to rescind an approved subdivision plat. So once you issue the approval, you need to understand it's locked in, and it locks in upon approval of the preliminary plat. The preliminary plat is where you lay out all your condition and note your final changes, and the final plat is merely compliance with the preliminary plat. It's not first we do a review, then we do another review. Everything is done at the preliminary plat stage. Okay? So once you put your conditions on the preliminary plat, what the applicant's obligation, regardless of whether we're talking about this project or somebody named Joe Smith who's just dividing his house in two so he has a mother-in-law unit next door for an aging parent. Their obligation is to come back with a final plat that shows the changes and compliance with the conditions required by the preliminary plat. Some conditions will survive the final plat and be noted right on the plat itself. No parking vehicles within 20 feet of a side yard line. There may be things like that you need put in place if it's an appropriate condition depending on the nature itself.
So wait, so let me get that straight. So there's a preliminary plat in front of you. The board says we will approve this preliminary plat with these added conditions. Then the applicant goes back, redraws whatever to include those conditions.
Right.
At that point, the planning board cannot reject the submission?
Generally speaking, if the final plat complies with zoning and the preliminary plat approval, it's a must-approve scenario.
Unless some crazy new information.
Correct. There are things that
Uranium
can bring.
site
I'm talking about general
contamination.
rules.
Okay.
Right.
Okay.
Yeah, there are things that can change the formula, but generally speaking, and you can see the cases, there's stuff in more detail. If you just, type in that case name, the Cornell LII site will bring it right up and you can read what the court
Okay.
themselves said. But the
Okay.
general rule is, absent fraud or substantial cause, once you issue the approval is issued,
Okay.
period.
Unless, also if they failed to meet the conditions.
Yeah, if they didn't submit a proper final plat, there's nothing to approve yet.
Okay.
Can that be argued, though? I mean, who decides whether they met the condition or not?
The planning board. Right. If you put 20 people in a room, I think you could decide whether or not, in many cases, based on my experience in a few different counties, you can probably decide how the vote might split based upon where the people live. Very often, that's what it breaks down to. So it's not to say there aren't valid points to consider for subdivisions and how you lay out roads and lots, but whether people are in favor or against it sometimes has to do with how far away from it they live.
May I mention something that sort of goes in line with this, and I won't mention specifics because I don't think it's fair at this time. But I live on a street in the village of Trumansburg, and what I found is that something opens illegally here, and if it stays long enough, after one complains about it, for instance, cars, 10 times more cars than should be at a particular, like a service station, full of oil and gas leaking into the creek that runs into our lake, Keep Lake, as if we don't have enough pollution there. What happens is, time goes by, and my answer after I say, what is this business doing in the middle of this lovely little residential area? Modest as it is, but it's a lovely little space. It's grandfathered. Then I went, this steps outside of our range just a little bit, but just to echo the same sentiment. The street ends in what started out as somebody that sold scrap bits of wood for grassroots to build your fires. And it has become a lumber yard, and I complained about it. Oh, it's grandfathered. So, enough time passes and anything in this village can go almost anywhere. So you have to be very careful that you don't let the time expand when something comes in modestly, and I think you were suggesting this, that later on it sort of gets more ambitious, and unless you stop it, when it does that, you're then stuck with it. And my answer to 3-4 of these questions locally here has been always the same. It's grandfathered. You missed your 1 year of opportunity to complain about it.
I can give a little historical insight on at least one of those.
Yes.
I assume you're referring to Mike's.
I don't want to,
But that definitely was there as a result of a special permit that was issued some years ago.
how that could have been issued at that site.
Well,
Is-
I don't.
But it's not,
It wasn't, whoever told you it was grandfathered.
That's what I was
It was
told.
actually reviewed by a village board. I don't remember if it was a zoning board or the planning board at that point. It was many years ago. And a special permit was granted. Guy referred to the fact that special permits are sort of on the out.
Yeah.
That's part of the reason why.
They don't have much teeth.
It really was just a way around zoning, or sort of spot zoning. And that's definitely not good policy. So, but just to clear the record.
It's not like squatters and
That
settlers
was not a case of being grandfathered. It was a special permit.
Okay, then that's what I was told, and even so, I thank you for clearing my mind on that. But there are guidelines as to how many vehicles can be in a space like that, and it's triple that. So, sorry to drift like this. but I just
I'm
wanted
gonna
to
say, we should probably talk about this because illegal uses don't get grandfathered.
I wish I could
You
do that.
can have, no,
I wish I could.
they don't. You can have a situation where you've sat on your right so long that you lose the power to enforce, but there's a delicate nuance between the concept of latches, which stops you from enforcing something after someone's done it for so long and you didn't seek enforcement, versus grandfathering. Grandfathering implies that you have legal non-conforming standing. An illegal use can never be illegal use. You may not
And
be able
yet
to
that's
enforce
what
it.
I'm living with in my
I
neighborhood.
understand, but that's, okay.
In other
So
words,
back to
it's
back to
not been
subdivision.
enforced.
Let's go back to subdivision.
Okay, so subdivision conditions of approval must be stated, and there must be a reasonable relationship between the problem sought to be alleviated and the application concerning the property. A condition of approval must comply with the constitutional requirement that a close nexus exists between the condition imposed and the impact sought to be mitigated, and the impact and cost of the condition must be constitutionally proportional to the impact or harm sought to be mitigated. So that's a lot of words, and basically it's talking about the two mandated Supreme Court standards. There must be a close nexus between the condition and the zoning power that you're exercising. And even if you have the right to place the condition, there must be a reasonable relationship between the scope and cost of the condition and the nature of what you're alleviating. So for example, if somebody had, we'll say, let's leave upstate New York so that we don't risk
Thank you.
touching anything that might be relevant. Let's go to the Grand Canyon, okay? And let's say the last strain of the Western Cooper's hawk is residing and routinely seen feeding and hunting in a field near Williams, Arizona. Okay? And the Western strain of this hawk, and I'm making it up, there's not a separate Western species of this hawk, I'm trying to be
Okay.
and let's say that the Western strain is endangered, and even if you're going to develop in a known, established, documented breeding ground for that hawk, you have to get incidental take permits from Fish and Wildlife, from your state environmental, whatever they're called in that state, and somebody's proposing to develop something there. And they're not in the nesting area, but they're in an area where it's frequently seen. Well, they may be required to get an incidental take permit, or they may be required to provide some roosting grounds or some spots on any tall windows that hawks might fly into so they don't see them. But you can't make this one developer pay for the cost of repopulating Cooper's hawks all over the Grand Canyon ecosystem because they want to build something. There's things you can do that are relevant to that particular piece of land, but the cost of repopulating a species is unrelated to the impact that might happen if one or two birds were incidentally taken by a tall structure in that location. And so that's sort of what they're talking about. There's a million variations on that theme where it runs into problems. If you have an area that's in a 100-year or 500-year floodplain, and you mandate that it be dedicated for a municipal greenway, well, okay, then that may, no question that flooding is a valid concern and a valid thing that a municipality can look at, but exactly why does making it a public greenway, what does that have to do, private versus public, how does that affect the flooding? Is the fact that it's publicly dedicated so that people are walking on a public greenway in the floodplain, is that somehow going to affect the floodplain any differently than if it's not publicly dedicated and people are using it? What's the difference? Why are you exacting the property? Because the taking of the property has nothing to do with the floodplain. The people are still going to be walking there regardless of who owns it. So you can get farther and farther away, and the Supreme Court has gotten tighter and tighter on these rules, and I'm using the greenway on purpose because that exact scenario came up in relation to Phantom Creek in the Dolan case, which is in your materials.
Okay.
So anyway, in short, subdivision review has some very substantial limits when it comes to the conditions, because in part, it is not really directly oriented towards the use of the land, but more oriented towards lot layout, okay? So the purpose New York State sets forth for subdivision law in the village law is, and I quote village law, for the purpose of providing for the future growth and development of the village and affording adequate facilities for the housing, transportation, distribution, comforts, convenience, safety, health, and welfare of its population. So the specific statutory purpose of subdivision law and village law is to anticipate and plan for growth and change. That's what village law section 7-728, if you want to look it up, says.
Well, and it is called a comprehensive plan, even not a comprehensive stop.
Well, and and comprehensive plans are required by law to take into account the entire region in terms of employment and housing and stuff like that. They're not metrocentric. They have to take into account regional things. So subdivision law left some real gaps because even though it helped supplement some of the land use controls that zoning wanted by really starting to, you're talking about an era where Revolutionary War roads and farming 2 tracks were still popular, 1909, 1910, 1920, 1930. All of a sudden, automobiles started becoming a major means of transportation. Railroads started to become on the decline, except in the western frontier. And now you're running into more problems, congestion, cars. What do we do about streets? These are 2 tracks that people rode a horse and buggy down to bring their products to market. Now we've got 600 cars in our village. What do we do? Well, subdivision plugged that gap and gave you streets and layouts, but it still fell short of what was needed as time continued to advance because it didn't really let you regulate the use itself. Nor did it do a darn thing when a use was proposed on a single lot. You can put in many places multiple buildings or an entire mall on one lot. And there may be multiple uses there, some of which you don't want. A store that sells chicken is very different from a plant that processes it. Okay, so site plan review came along years later and was substantially revamped on a statewide level in 1993 to put a little more teeth and clarity into it. But it really filled a lot of the regulatory gaps left by zoning and subdivision review, and again, especially for single lot developments and regulations based on the land. But it has the same constitutional restraints. It's just a broader, more effective tool. You have more discretion. Okay? Site plan review is sometimes referred to as ALD, arrangement, layout, and design of a site or a project. Because its standards are defined and are not inherently quantifiable, something like an aesthetic standard, or whether or not a buffer is going to be
Wait,
sufficient.
can you say that first part again? The line that's quantifiable?
Like an aesthetic standard, where you
No,
have...
yeah, I just, that literally, that sentence.
Well, a site plan is a review of the arrangement, layout, and design of a project, and because standards are not inherently quantifiable, they tend to be subjective. Determining whether or not something has the look of the immediate surrounding and blends in, it's a highly subjective determination. That authority to make that determination has been delegated to this board, and obviously if the building is going to be painted blaze orange with purple stripes, I think we can reasonably assume it's not going to blend in with its surroundings. Okay? And I've given you a really good case to look at on that called Raleigh Motors. And it was a historic building designed by a famous architect, and a car dealer owned it and wanted to revamp the showroom to go to a modernistic chrome and blue mirror design.
Where was this? Where was this?
Not all the way downstate, partially downstate. And it was a historic building, and the nature of the building and its architectural significance and what surrounded it served in and of itself as a documented historical buffer in the comprehensive plan between the residential and commercial zone. And they completely shot down the applicant's attempt to take this historic structure and gut its facade and turn it into this chrome and blue mirrored, sports car outlet. They allowed him to do a number of other things, but they didn't allow him to alter the aesthetics of it because the impact would have just been devastating. And there was a lot of proof in the comprehensive plan as to the significance of this building, etc. But that's a subjective determination, and the court said that subjective determination in that case was exercised properly by that planning board.
Because this does seem like a super squirmy area where it is sort of up to the taste of the board and a very, it exposes you to some lawsuit that then is up to the taste of the judge.
What your obligation to do is to apply the law fairly, to apply the law reasonably, rationally, and consistently. In other words, if you've always declared that earth tones and natural blues and muted blues and tans and whites are consistent with architectural character in a particular area, and then suddenly you decide that someone can't use blue, it has to be yellow, Why?
Right.
What changed? So you want to be consistent, you know, don't tell Mr. Smith you have to do it this way, and then tell Mr. Jones you can't do it that way. Just prior precedent matters and being consistent over time. That's the leg of the stool called equal protection. Applicants are entitled to the same fair look regardless of who they are. Okay? So, because the standards of site planning are broad enough to allow pretty fair amount of discretion and are inherently tend to be subjective and not subject to easy quantification, imposing strict conditions becomes a dangerous balancing act. And that's what the Supreme Court and a lot of the New York cases deal with. So there's lots of rules that I can give you as a thumbnail sketch that generally apply to almost all site plans. And I summarized a lot of what's in there, but I distilled it down to 7 quick points, and I'll just read through them. 1, an allowed use cannot generally be denied under the guise of site planning as the legislative determination of compatibility with surrounding uses in neighborhoods has already been made. The rule is actually broader than that because it says compatibility with neighboring zones is also a determination that's already been legislatively made. It was legislatively
So
made.
if there's
The adoption of zoning.
open land in a business district, you can't deny an application for a business based on it being a business.
If it's an
Because
allowed use,
it's
it's
an
an allowed
allowed
use. Right.
We have a perfect example right now in Cherry Street Industrial Park.
Oh, okay.
It has small 1- and 2-story industrial entities and proposed is a 5-story bunker of an apartment building.
Oh, so.
So,
not
and
residential.
McGonigal, I think it was the only voice against it, but it talks about color, size, dimension, shape, where it is, the beautiful little strip of land right on the canal there, or what we call the inlet. But that's a perfect example, I think, of what you're talking about.
2, a site plan may not be denied because the planning board interprets the zoning as not permitting a proposed use that the zoning allows. 3, a site plan cannot be denied as a consequence of effects which are common to the zoning, neighborhood, or area. So for example, and this, you know, if this were a desert, if we were in north of Arizona, you know, Phoenix, and you could extract enough water out of land you own to service your subdivision should be approved. You can't, as the planning board, require that applicant who's building their subdivision to extract more water to solve the water shortage problem for the rest of the desert. Lack of groundwater, lack of rainfall is endemic to all deserts. That applicant can't be made to pay the price for solving that problem for the neighborhood.
And the point you made right before that one was, the planning board can't just misinterpret zoning and deny an application.
Right, well, the planning board's job is, zoning interpretation is not inherently the authority of the planning board.
Okay.
You have some tangential authority there, but you don't decide whether a use is an allowed use or not allowed use.
Okay.
And this dovetails back to many moons ago when the plan was, let's send this for an updated opinion to the zoning officer, and we were in the process of writing that up, and an appeal came and dropped it on the
Okay.
and froze it out.
Okay.
So, 3, or 4, a site plan cannot generally be denied for impacts inherent in the allowed use itself. So for example, if you have a zone that permits restaurants and nightclubs, you can't put a condition or deny the use because nightclubs tend to produce late night traffic and crowds that drink and sometimes are noisy. It's what a nightclub is, for God's sakes, and it's an allowed use.
Okay.
If you don't want nightclubs there, then you better change your zone. That's what the law is going to tell you. 5, the planning board lacks authority to impose conditions which are unrelated to the legitimate purposes of zoning. The most classic example where people run into that in New York State is trying to extract cash or land for recreation or parkland purposes. Generally speaking, you should have a comprehensive plan because it's not your property. And you can't extract property rights in exchange for a municipal approval.
You can't require a village park on someone's private property as part of the development.
It is difficult to do properly unless A, the applicant simply agrees, and many of them do because pathways and parks
Right.
actually augment the saleability and value of the lots. So there's a give and take in some of this.
But that's in our zoning bylaw, right?
Well, do you
The requirement for public land.
Right, and do you have a master plan that shows a lack of, parkland and recreational land in this community that supports that exaction? If you have that kind of master planning information, for example, the town of Ithaca, the executive summary of their recreation and master plan for their pathways and parks, the executive summary is 98 pages. Not the plan, the summary. Okay? So, and I've been, representing and working with the town of Ithaca for years, and you can see after all these years how the different trails and pieces are all starting to make their connections. It's all starting to work, and it took a lot of full revision to get there, and sometimes developers come to the table kicking and screaming, but it is what it is. 6, speculative and conjectural fears concerning future impacts or generalized or even strident community opposition rarely constitute a basis for denial of a site plan application, nor can it support unreasonable, onerous, or confiscatory conditions. What you have to base your determinations on are facts, evidence. Opinions do not rise to the level of evidence. That's why you go to people that are called traffic engineers. Okay? 7, a denial or an onerous limiting condition related thereto for an impact generally cannot stand unless it is invidious. It must be an impact that other allowed uses in the zone would produce. So if you have, and there's a great case, it is actually one that a lot of people hate. It's called the Robert Lee Realty Standard. And it has to do with a movie theater, redoing them all into a movie theater with a school across the way, and this and that, and the board was like, roads will be paved with the lives of our children, there's a school across the street, a movie theater's going to have late night traffic, which of course begs the question of what the children are doing at school at 11 o'clock at night on a weekend, but we won't go there.
Looking for a nightclub.
We're logically speaking a whole lot of reasons why there was a good solid basis to be pretty concerned about this. It wasn't just the school, there were other things in the area, there were other issues. And the court said, well, hold on a second. What is it that a movie theater produces in terms of noise or crowds that is any different from the other allowed uses in this zone, like department stores and restaurants and schools where you have a large volume of traffic, large use of a parking lot, all in a discrete defined period during the day. So a school does that from 7 in the morning till 3 in the afternoon. Your department stores that are down the street do that from 9 in the morning to 9 at night, and you have a movie theater that's going to do it from 3 to 11. What's the difference? What is it about a movie theater that's so different from all the other allowed uses in the zone? Why are you singling that use out for disparate treatment? And the board went down in flames on it because there was no explanation for that. In other words, if you have a problem that all the other uses that are allowed in the zone or other allowed uses in the zone would also produce, get your facts, build your record, don't wing it. The most commonly misapplied standard due to it being inherently troublesome and largely subjective is the effect on the neighborhood standard. Generally, this standard allows modification of layout and design to mitigate impacts, but it rarely allows actual denials unless there is and I'm going to use the language the courts use, proven significant, non-mitigatable, and deleterious impact upon the community of a nature as directly harms public welfare. And I lay out a bunch of examples that are actually sort of surprising. The Summit School case, conditions limiting the days and times of educational classes, allowed athletic activities, and student-staff ratios wholly improper and invalidated because they related to the details of the business and not the zoning use of the land. Needless to say, schools are treated differently in zoning. If they're religious schools, you better be really careful because there's federal protection for them. So, 2, the Sedano case. Condition limiting the number of dogs being trained at any one time in a kennel is improper. It's a kennel. They're going to have dogs and dogs are going to bark. If it's a use, it's a use. Schlosser, conditions as to maximum number of employees and hours and days of operation improper. Old Country Burgers, limiting drive-through window hours is an impermissible regulation of the details of the operation. Cove Pizza, the denial is improper when based on a quota or overabundance of similar uses. That one was really interesting because they said, yeah, we know restaurants are allowed, but we've got 8 fast food restaurants in that area. We don't need a 9th, we're turning it down. And they said, nope. If anything, what that establishes is that it is precisely consistent with its neighborhood uses.
Okay. So I have a question
There are
about,
ways to deal with that though. They're called floating zones, but let's not get into that.
so I have a question about the hours of operation and like what are your kids doing at school at 11 o'clock? And what if it was a night school as well? Does it matter? Like, is there something that says that the school's hours must be?
Well, schools
And
are,
if you extend beyond that, then you're suddenly not a school or?
municipalities have very limited abilities to do site plan reviews of schools because of their public purpose. And so
Okay.
what this was talking
Is
about
there
is a
certain
type of
public
like a day school, a private school, right, the rules have changed, but this is illustrative of when you're trying to say, well, we don't want kids outside at this time, you know, practicing football because it's noisy and the crowds will be cheering. Sorry, that's what a school is.
Okay.
It's, you know, I literally had an objection in the town that will remain nameless because somebody was putting in a soccer field adjacent to existing fields. And a group of neighbors objected because they found the sound
Soccer.
of children playing offensive to their ear and disruptive to their rest of their repose.
Oh.
And
Well,
fortunately for the applicant and probably the entirety of that town, and unfortunately for the complaining neighbors, there was a deputy supervisor in that town who brought the person up to the table and said, I'm sorry, but it is within the declared public purposes of our community to have safe neighborhood-based playgrounds for our children to play. We are going to support local playgrounds so children don't have to cross roads or travel or drive to find somewhere to safely play. Your objection is not going to be given any weight beyond this point. We've heard you say it 15 times. Please stop. And that person has since moved and is now the mayor of a rather large municipality not far from it.
With no playgrounds whatsoever.
Tons of playgrounds, actually. A lot of lakefront property too.
Okay.
Some of those cases have really interesting facts, but what you distill out of them as quote unquote its golden nugget is somewhat surprising because you would naturally think, well, you know, yeah, do we really want 10 pizza shops? Well, that's not something you can decide if it's an allowed use, it's an allowed use. So what I'm going to say in trying to get to how to distill all this together, please carefully examine the U.S. Supreme Court cases. They're very closely followed in New York. I provide you with a string set of New York cases that illustrate how they're applied. But the 3 to really look at are Nolan, Dolan, and Koontz. And yes, they arise in different states. Nolan was a taking by the California Coastal Highway Commission. Dolan was Fano Creek, it was in Oregon. And Koontz was in Florida and is the most surprising of the decisions if you really understand what was going on. But if you understand what the municipality did, perhaps it wasn't that surprising that the Supreme Court said, you can't just take someone's property. So, for example, in Nolan, the imposition of overbearing regulations or conditions can constitute administrative taking, including property rights. It can also create 1983 problems, which is a civil rights, property rights, due process. If your civil rights are violated, anything that you're guaranteed under the Bill of Rights is violated. You have the standing to go to the federal court to seek redress under 1983. And even if you only prove minimal damages because you were falsely arrested or something like that, the statute punishes the municipality that conducted the taking of those rights by awarding full attorney's fees and all sorts of stuff can get added on. In other words, the federal government is saying, stop it. People have these rights and you can't take them away. We had an entire war over this stuff. Please stop doing it. So, one of the things that for those of us who practice in land use, we're really happy that the Supreme Court has not kept this as their hot-button issue. 20 years ago, this was the big issue in the Supreme Court, where anything that went up, municipalities were getting hammered because they were taking cases that they could really make an example of. That's why I take a look at those cases, because my advice is universally, please, 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 only let me read about this in someone else's town or village. So The Nolan case was really what kicked it off, and just to take 2 more minutes, what happened was people had beachfront property in California, and California, much like the state of Florida with its state statutes protecting wetlands down towards the Allegheny Valley side of Florida, but in California they had this like 30-40 year process of grant writing and statutes and regulations to create a coastal commission highway and an interconnected trail that went along the beach, and these people, the Nolans, actually happened to own a piece of land with a seawall directly adjacent to the big park, and they needed to get the trail there. And they wanted to take down their little cottage and put up a big 3-bedroom gorgeous house. And they got their site plan approval, but subject to the requirement that they dedicate an easement to the state of California to connect the park and the trailway and create the beach walkway. And the Supreme Court said, perfectly valid purpose. If you would exercise your eminent domain power because there's a public interest in that, you very well could have done it. But what you can't do is take that property in exchange for the granting of a right to build a house. The ability to walk along the beach on a public trail is unrelated to someone's right to build their house on their own property. Where's the connection? This is absurd. And if you read the dissenting justice's opinion, it's, you really, in here I just sort of think on that really closely. And if you have questions about why I say, just think about what the dissenting judge said. I'll explain it to you, but it comes down to this simple question. Well, if they merely increased the price of their value and the taking of their property rights didn't reduce the value of their land, great, then all we're talking about is money. How much is your right to vote worth? Can I take that? The Supreme Court said, no, we're not monetizing rights. That's not what they are. So that's sort of like the quick version, the overview, the hot points. There's a lot more to it. And, you know, to the extent that it's within my authority, which it's not, to give you homework, something to look at, something to read, and look at how these standards work and how they mix together. You have a lot of discretion, but it's not unbridled. The conditions have to be tied to something in your zoning, and the conditions have to be proportional. The harm that you're seeking to alleviate cannot be met by a condition that bankrupts the developer. There has to be common sense connection between all these elements to make the condition valid. And there's no point in considering issuing an approval with conditions on it if you can't enforce the conditions. Whatever you're going to write as conditions need to be supported in the record, and I like to use the phrase bulletproof. And that's my goal, to assist you as you try to put these conditions on paper, how to document their existence and write them in a way that makes them clear and not subject to challenge. 10 years from now, when someone says, that's not what that means, you know, I want it to be clear enough so the next planning board goes, no, that's exactly what it means.
Can I ask a quick question? So we have a developer in this case who's been, you know, very flexible, malleable in terms of responding to requests for mitigation and things like that in their planning. So if we impose a condition that they consent to, is it still a condition, or is that would have to meet these standards?
Consent cures
Everything.
yeah, well, no, it doesn't cure everything, but it certainly removes a lot of taint. But what you have to understand about conditions is that whether you want to acknowledge it or not, you've already imposed a lot of conditions.
Yeah.
Because if you go back, like I came into this after they'd already been in the process for quite a while. And there's a group of documents that preceded my tenure with the village. But I did get some of those maps, and I look at the original proposal and then the second generation, the third, and I'm like, the process has substantially reduced the size and density of this project. There's been a lot of changes as each iteration has come in. So
Vicky's first point again.
right. And whether or not those changes are for the good or for the ill, that's what your board's going to review. But when you look at the connection of the condition to the police power and the reasonableness of the condition, you can't divorce the fact that a number of changes have already been made. So that is part of the calculus. What did you start with, and where are you now, and what's the final determination? If they've already mitigated the concern by adding, let's say hypothetically, 70 more trees, then adding a condition for 70 more is gonna get you in trouble. So what you're gonna determine is, what have they already taken care of, and what do they yet have to do? And to Vicky's point, have any of the changes triggered something new?
I have to beg to differ a little bit, even though I'm in agreement that it's been through many altercations. I first saw this proposal on the front porch of this village hall with the architect Claudia Brenner, and she showed us a small circular motif without Ithaca Neighborhood Housing Services, so some small, very nice little cottages with large yards. That was, maybe some of you saw that, maybe some of you did not.
But that wasn't one of the planning board.
No, it wasn't an application.
It wasn't a formal application, it was the first drawing.
This is
Proposed
so
for that
this
site.
is citizen Victoria Romanoff chatting with citizen.
Well, there
Brenner.
were quite a few people, and I think
But it was, again, to be
it
clear,
wasn't a formal meeting.
no more
It was the
submission.
first presentation I saw of
Somebody thinking
what
about
she
doing
thought she was
something
gonna
with
do
her
there.
private property.
Yes.
Okay?
Then the lot turned out to be very complex, and the amount of money to be spent there with drainage and so forth. Then she involved, the Ithaca Neighborhood Housing Services, and now we're seeing, I think, the fourth variation thereon. So I'm trying to absorb all the changes and what has been added and what is, they're considerable ones. So I'm still sort of foraging.
Okay. You can ask a question.
The changes are either for good or for ill, that's what the planning board will review.
Yeah, that's what I hope we talk about.
I
Yes.
asked the question.
Just one?
Yeah.
You're slipping.
No, I
So-
think, I think this question, I'm just, as a practical matter, I'm sort of trying to think about how this might go, If we say, okay, we want to impose this condition, we'll grant this, but we want to impose this condition, and the developer says, okay, no problem.
Well, okay, no problem to the concept versus what they may ultimately see when I put it in writing are two different things. Or
Yeah.
you put it in writing and I
Sure.
edit it, whatever the process is going to be.
Understood. Yeah.
So, verbal consent is not necessarily
No,
written
I wasn't
consent.
suggesting it to be verbal.
Right, so.
But if they consent, then they incorporate, then they do.
So we just, they incorporated it in the thing, and it's not a condition.
If it's already been taken care of, it's not a condition. So for example, like the classic example is someone comes in with a site plan for, let's say, an event facility. They want to do a bed and breakfast that has a large tent site. In the summers, they can do weddings and stuff and, draw guests to their facilities or whatever it is. Who knows? Maybe it's converting an old barn. That's a big thing right now. The adaptive reuse, which has become a type 2 action under SEQRA. Adaptive reuse, you don't even have environmental review on a lot of that stuff now. So, they come in with an original sketch plan and the planning board reviews it and says, well, okay, this is your lot and this is where your barn is, but you've got a neighbor here and a neighbor here and a neighbor here and a side road. We think you should intersperse a double row of deciduous and evergreen trees with some fast-growing willow shrubs to create a visual and sound barrier because, okay, you're not going to have live bands and they're going to be more sedate, stately weddings, but still, 100 people in a tent is going to produce noise. And, we want this buffer. And so they say, okay, we build this giant thing. They put in a berm, they raise it up so that the berm deflects sound, they put in all the deciduous plants, they bring in a landscape architect and really build it up. Okay, you don't have to have a condition saying that you have to install a buffer. Their site plan now requires it. But you still would want a condition to say, look, you have to maintain it, any diseased or dying trees have to be promptly replaced. If you want to remove or alter any of your major plantings, it has to be pursuant to an arborist plan or a landscape plan that is approved by the board if you're removing more than any trees over 3-inch caliper, whatever this, and you have that actually in your site plan law.
That they have to
You have
maintain
those kind of
them.
standards,
Yeah.
maintaining vegetative buffers. A lot of municipalities don't have that.
The thing I've been impressed with, the design process is exactly that. It's a process. It starts somewhere and it evolves, and what comes out sketched out the first day, the
She became a property owner.
property.
You know, it's interesting on that is there's a huge piece of farmland in Lansing, right near the town center, that's the Kingdom Farms. And it's a Jehovah's Witness. And originally, there were water and sewer agreements in place for Kingdom Farms because it was going to be the North American printing headquarters for the church. It was going to be a whole standalone, self-sustaining community using that farmland to grow their own food, and they were going to have a major printing operation there. And the water and sewer took too long, and land development being what it's become in the past 20 years in New York, they eventually went elsewhere. They Googled New York, or Amazon New York. And so at one point, the church was looking at selling that land, and there was a huge hullabaloo. Everybody, no, it's got to stay agriculture, we don't have farming. Well, that's great, I agree with that as a concept, but it's not your land, buy it if you want to save it. Unfortunately, there's enough influence from people that are of that church in that town to help it actually end up getting sold as farmland. But the first developer came along and decided, it got so much opposition that what they did is they took like all 500 acres and laid out 1 acre lots on the whole thing. Just turned it into a giant, army barracks type of thing and said, this is allowed under your zoning. I think you should stop complaining about what you're thinking about. And fortunately, that didn't happen, and it actually ended up getting purchased by another farmer and stayed in farm, and it's going back into the ag district. So there, a lot of good results ended up, but not because of any careful planning, but because that's how it worked, and it was a landowner that had so much history to care about the land. That's a good problem to have.
So I kind of butchered my first attempt at talking about the document that really is more rough than I remembered. But I kind of want to talk about the time because it does inform our thought process, our diligence and review, our being tight in our work as a board. And we can talk about whether or not, Vicki, not right now, I mean, we should address if the final preliminary plat presented is significantly different from the first public hearing. So let's just say, it is. So within, I'm looking at this, and this is real, right? So 45 days after the submission of the final preliminary plat, there would be a public hearing. Then 45 days after the conclusion of the public hearing, it doesn't have to be, it could be within that, but you have to move, right? And you could have a public hearing before 45 days. It's not like you have to wait, okay. The planning board shall approve or disapprove the preliminary plat, which means if the preliminary plat is submitted, then we have maximum 90 days to make a determination. Because within 45, you have to have another public hearing, and then after that 45, you have to make a determination. Or you can do it sooner, or you don't have a public hearing, and then you have to make a determination. If you waive the public hearing, you would have to have a determination in 45 days of submission.
Right, if you say we've already had our public hearing and we may exercise our action to have a further public hearing at the final plat stage, which you can. In fact, it's required if the final plat has substantial changes from the time.
If the final plat from the preliminary plat, but not from the...
If the final plat from the time of the public hearing on the preliminary plat, the final plat should always be in accord with the preliminary plat.
Okay.
But it's sort of like the SEQRA process. SEQRA has a specific regulatory provision that says it is incumbent upon all lead agencies, and all agencies in fact, to commence and complete the SEQRA review as early as is possible in the process.
Right.
In other words, you're supposed to get it done fast and early. That doesn't mean that you can't, as the project changes over time, go back and say, well, we made this determination of no significant impact because of this standard. Has it changed because the project is now 12.2 versus 12.1 acres? Or did it increase in size because it was actually mitigating the impact in and of itself? If the project has changed because the impacts that were looked at under SEQRA have been mitigated, you're probably not going to trigger a supplemental review.
Right.
But you have to take the look, you have to make it a reasoned elaboration, and if there's a reason to take a look at something under SEQRA, take another review on it and re-examine it. You may end up continuing the negative declaration, you may not. But it's gonna depend on whether or not one of the standards, if you would move something from no significant or anticipated impact to potentially significant, moderate, or significant impact, then you're gonna have to do a supplemental review.
Well, that would be,
That's
but
what it
that's sort of a little bit different. I mean, this notion of the public hearing that we had and what drawing the public hearing was on is different than what the SEQRA drawing was on. Because the SEQRA drawing that we were working from the plans have not drastically changed.
Right.
Or
Well,
I mean, one of the things
but
that.
what I'm getting at is
says
it's the
that.
same standard, is that just because you had a public hearing on this preliminary plat, and as you pointed out, it's gone through 4 iterations, you don't have to have another public hearing on the preliminary plat, but if the final plat is substantially different from the one you had.
Then you have a hearing on the final.
Then you have a hearing on the final plat.
And the purpose of the public hearing is simply to get comment.
To get comment,
Right.
make sure that if there's any final tweaks, changes, something you want to do, you try to do it.
But how can you do that at the final plat stage?
Right.
Okay.
Right. That's the underlying problem. That's why I'm saying you can do it. A lot of times the applicant will consent. There are some things you can do at the final plat stage, but I'm just going to say take your hard look and get your conditions, nail them down clean at the preliminary plat stage, and then fine tune it if you need to at the final stage. But you know, how you as a board decide to go forward, that'll be up to you.
Quick question. I think since we first started this process, the SEQRA review has gotten stricter than the one we used. Or at least there are new guidelines and laws very recently established. I don't know if we're working under those or should be looking
I
at
don't
them
think
at
we're
least.
required to.
Because the guidelines for SEQRA are getting stricter. I don't know if they've been initiated yet and are in place, but we should at least think about that, or maybe.
Well, the new SEQRA regulations went into effect January 2019. They're in effect. They've been adopted. The finding statement was issued under the EIS. They're in effect.
Did we have those as guidelines, those new ones?
No, because we began secret process in
The
August.
new guidelines
2018.
apply to new applications.
Right.
So if an application, if the review had started or the application was in under the old guidelines, you generally apply the old guidelines. But it's not necessarily true that SEQRA got stricter. The EIS process, you no longer have an option to do or not do scoping. Scoping is mandatory now.
Scoping, what do you mean?
When you make a positive declaration, you don't look at everything all over again. You look at the one thing that triggers a positive
certain
declaration.
issues.
You look at the scope of what do you have to examine.
Okay.
Which is one of the grand ironies of the EIS process, because sometimes you look at something so thoroughly in the EIS process that you've got all the expert opinion you could possibly get, you still think there's an impact. So you go through the EIS process. So you go into a scoping session, you say we need to look at that, and absolutely no new evidence.
Right.
Okay.
So, but what you're looking for is the equivalent of planning MMI, maximum medical improvement. Have we mitigated to the reasonable extent capable under no law and science? And
So again, to beat this
the
horse,
SEQRA it got actually a lot looser on the EAS side, on the earlier stages. There's a lot of stuff that's now type 2 that never was.
Do you think it got laxer?
In some respects, in many respects it did.
No, in some ways it got laxier.
so Guy, if Morgan goes into the office tomorrow and any applicant has put in something stamped, because there's those regulations that says preliminary plat, final plat, preliminary plat, we have this timeline. We have these 45 days that we have to have a public hearing and review it.
Yeah, if they've gone through.
And that's really up to the applicant. I mean, they even were in discussion phase with 46.0, they could at any point make that final submission. It'd be shocking. I mean, I think we'll have anticipation of that, but.
Right,
They
they've
just won't say
indicated that these are pretty much their final plans, but they have supplemental information they're still in the process of providing,
MRP had some.
including, right, to give MRP a chance to go through it.
Okay.
I was just gonna say, when you go through that stuff and you have questions about some of those slide shots I showed you, certainly let me know, I can answer questions. If you have enough questions as a group, maybe it's worth doing, sorry to tell you, but that's all pared down from 72 pages that I did for the Planning Federation.
I was having trouble following the 1, 2, 3, 4, 5.
I just filled it out because when you really break it down, it's not as simple as that. I wanted to give an overview and let you take it home, and everybody that reads it is going to extract something different of value out of it. And it's as a group, that's that. Right.
And read those Supreme Court cases, John.
Yes, right. They're actually rather fascinating. What's even more fascinating is some of the commentary that came out after, like the case on the signs, the Gilbert, Arizona case on signage involving the church, and all the commentary about the sky was falling. It's like New York's followed the correct constitutional standard for 20 years when it comes to message regulation and signage rules. And a lot of states hadn't. So everyone was saying the sky is going to fall, all our sign regulations are going to be invalid. It's like, hey, what do you know? New York's been on the right side of this for years. So it's funny reading commentary because the first thing that people do is react.
Well,
And then thought comes in and you start seeing, no, it's not actually that bad. I get it.
presumably you can access the Supreme Court rulings. I mean, like if you Google Nolan and Dolan,
You'll get them.
You'll get thousands of pages of commentary. They're two of the most discussed cases in the history of land use in the history of the United States.
Those
Nolan and Dolan, yeah.
sound like a couple of cookies.
Well, California and Oregon, you could make a joke about that, but I'm not going to because
Okay, before we get on chatting, we should either adjourn or move on to the other agenda items. I think that this was more placeholder for further discussion. Victoria wanted to address, that we should address alternative energy in the village. Right, so you want to make a few things about it? Yeah, I think, and speak to you, you just wanted us to be thinking about this for further discussion.
Yes, I think any new business or residential area or business that comes to this village, including our own houses, I'm certainly doing things about it in my house right now, changing my hot water system. I think we should explore very carefully solar, geothermal. Windmills have a poor reputation on birds they kill yearly. That doesn't mean to say they couldn't have netting or some kind of protection device. I think in terms of this project, I've been asking for the last 2 years, what alternative energy might you bring to this? You have an abundance, maybe even an excess of water. You might have warm soil conditions you can use. Again, I have reservations about the windmills, but I don't want to dismiss them. But I definitely think if I was to think of a condition, since I have mentioned it so many times at so many meetings, what alternative energy sources are you thinking about?
Yeah,
Now,
we did.
lighting is fine. But
We
it's
did
a
address
baby
that
step.
specifically last meeting, and they said they were going to
Explore that.
They're having remember they were having a green energy conference or something because what we were talking about.
Okay.
Burdette Firehouse was able to do geothermal. What are your plans? So I feel like we're going to hear some things.
Good. So.
But I was also thinking that our village is small, and so the amount of land that could be developed in this solar farm is not very many parcels. But it should. I want, when Tom, and he's not here, because we didn't require him to be here, I think we should look at what our zoning code says clearly about what can happen, and then maybe it wants to inform the rewrite that's underway.
Inevitably, it is cheaper to put on farm fields, but if our immigration policy changes at the borders, we might need some farm fields in every state.
So we should look at, I would like to look at our map, right, in our code.
I think every civic building, every school, anybody that has a reasonable south-facing facade without cutting yet more trees should be explored.
Yeah.
Residential, it should be encouraged and it should be done. And there might be, new ones are emerging. It's amazing what they're doing with just using groundwater and amplifying it by some additional heat. Totally off, may I drift off?
No, wait, if you're going to drift off alternative energy, let's just finish that by saying, let's all sort of look at this, let's think about this, because the planning board thinks about how it plans.
Have a meeting about it, maybe?
Well, I don't know, I'm looking at, next month's going to be real busy, that this application process in front of us. Yeah, but let's not lose sight of it, let's connect with Tom Myers, let's put it back on the agenda, maybe not for May, but for June.
Okay, what
Do
if
you
we
think? And you
bring
can
in
meet with anybody you want to chat about it, sure.
editorials, take photos, listen, you know, maybe
Yeah.
give some evidence of where it's been done, how effective is it? So
Yeah,
I'm
what
sort
are
of
the
curious,
pluses and minuses?
I'm sort of curious, is there excess capacity that, we do have a solar farm in Trumansburg.
in the village?
It's in town.
It's in the
That's
town,
in the
well,
town.
it's in the town, okay, not that far away.
We could
Well, no,
have-
I'm sorry, but I'm all like, wait, what?
But the question I have is, do they have excess capacity, or have they sold all their panels, or?
I heard they have
Ah.
some left. So somebody that can't install it for some reason could tap off of it and pay for it, yes, yeah.
Okay, good.
But when you
things to
see
think
the
about.
size of them and the amount of, you know, it's much cheaper to put in a farm.
Sure.
But
Okay,
Ithaca is finally looking into, you know, some of their parking garages and what they're doing with that.
before you stray onto
Yes,
something different that might be new business, should we just address if we have any old business and then we can just.
I have a tiny old business.
Oh, you do, okay, great.
Yes. I would like to thank, I hope the board agrees with this, to thank Peggy Hain and John, who I saw with her, for putting all the wonderful plantings in, where we had the entire beautiful canopy to our village destroyed. The trees, I'm not fighting for the old silk cottonwoods, they were tired trees. Nobody had the brains to plant something new in between, to maybe fortify it a little, protect it from the falling branches. So then it was all clear cut. I live right next to all that, and it was very, very
So they all
disheartening.
drive in and out.
But I think Peggy Haynes should be thanked publicly in some way for her efforts.
And there's more to come, I think, next year.
And I heard they're gonna, you know what they are, they're red buds, right?
Well, a lot of red buds, crab apples, and corns. It's a crab, not a crab apple, it's a dogwood, it's a
Oh.
red, not red.
Not
I'm
red
sorry,
buds.
it's dark.
And
I've been labeled.
And they're on the network, so when they get to reach their capacity, it'll make a wonderful sort of, you know, we might still want 2, 3 larger trees that may be where we hold our concerts, because they have a beautiful strip of land just at back of all this.
can someone help me with this? Isn't there a way that right now as a board we can make note in the public record, because we're having a public meeting, that we'd like to officially thank the tree committee for thinking of
Was
the
this the
community?
tree
It was,
Or whatever, we just do that now.
Peggy Hain was the initiator, and she did it through Rotary. She got a grant from Rotary to cover the cost.
Okay,
And then put together a group.
or is it just enough that it's in the minutes? Help me here.
Well, I think if we do anything official, we probably have to make sure we've got all the right people and all the
Same.
right organizations mentioned.
A resolution that makes a proclamation.
A resolution to make a proclamation.
Something like that,
Thanks.
just a proclamation of thanks.
She actually
initiated it.
There's something in the Free Press, I'm told, that she wrote. There was something actually in the Ithaca Times that names names.
Victoria, would you like to, since you proposed this good thanking, would you like to track down all the people that we should officially thank? We're going to have
Yeah,
a resolution to make a proclamation.
Yeah,
Excellent.
that's who they were, yep,
Okay,
People and organizations.
yep.
and anyone who generally loves trees, can we thank them too? Okay, any other new business? I'm sorry, old business, can we close old business? Any new business?
Historic district, anywheres, anytime, or the village.
Dude, wait, we keep bringing that up, and then we say, what if, didn't we address that? You gotta get, your community has to vote, that's like a comp plan thing. You gotta get the village to decide
I've done
what it
all
wants to
that.
identify. You get
Dead
people to
end.
decide that what you have a comp plan, I'm no longer on the committee, by the way, of the comprehensive plan and zoning revision committee. I resigned. Yeah, got too busy,
Yeah.
and my babies aren't
It's
gonna
spring.
stay babies.
It's spring.
I think you have to get the community to identify and recognize and support that it wants to have a historic
But
district.
that's exactly right, the comprehensive plan.
That's the way to do it.
Go
So,
through that again. Okay.
well, we're going through that anyway. And then, so let's see, well,
All
Kathy
the
was here.
paperwork has been done, or, you know.
No, but I mean, like, there's a process that you, because you can't just go and impose. This is now a historic district.
No,
Right.
of course not.
So-
It came before the village under two different mayors.
Your county support.
Well, maybe you'll have more support now, and I think there is a vehicle to have that if you have a
Try it.
under review. And the committee you can reach by contacting Tammy, and can get you to their mailbox if you want them to consider, because that's their job, collect everyone's concerns. Okay, any other new business? Motion to adjourn.
So moved.
Second.
All in favor? Any opposed?